Welcome back to the Nature of Government. This is video 4 entitled, Who Defines Our Rights? Just before he uttered his famous line from Scripture, "A house divided against itself cannot stand," Lincoln said this, quote, "If we could first know where we are and whither we are tending, we could then better judge what to do and how to do it," close quote. Lincoln is saying we need context. To understand the present, we must understand the past. Today, we're going to learn a little about how modern liberals and modern conservatives see the nature of our rights and how they came to see it that way. We'll learn how Lincoln, applying natural law principles, generally understood the origins of our rights. We'll find that he rejected the antecedents of today's liberalism and conservatism present in his age. Let's start with what I promised you earlier. It's time to compare the philosophical underpinnings of Lockean liberalism with that of what we call liberalism today. To do it, we'll examine 3 views about slavery in America during the decade before the Civil War. 1. Slavery is morally wrong and should be prohibited. 2. Slave ownership is a constitutional right. 3. The people should decide whether slavery may exist in their state or territory. The first view, that slavery is morally wrong and should be prohibited, is Lockean liberalism. The second view is not. Slave ownership is a constitutional right. That view denies that all men are created equal. How about the third view, that the people should decide whether slavery may exist in their state or territory? That's this episode's drama. Who decides? And there we'll find the difference between Lockean liberalism and what we call liberalism today. Our curtain opens, again with Abraham Lincoln, a former state senator and U.S. representative from Illinois, traveling the circuit in 1854 with some fellow lawyers and the circuit court judge. Coming down to their inn's main floor from where they had slept well the night before, the judge and the other lawyers found Lincoln staring into the fireplace. Lincoln had stayed up all night, agitated by the nation's newest law. Congress had just passed the Kansas-Nebraska Act, which claimed to finally solve the nation's divisive slavery issue. The country had been divided for decades over whether slavery should be expanded into the new territories that were becoming states. The old Missouri Compromise that had allowed a shaky peace since 1820 was in ruins by 1850. The Missouri Compromise had used a federal and geographic approach. Congress fixed the latitude, dividing the Louisiana Purchase into slave and free territories. But the Kansas-Nebraska Act of 1854, championed in Congress by Lincoln's longtime Illinois rival Stephen Douglas, purported to finally solve the slavery issue by letting each new territory decide by majority vote whether to allow slavery in its borders. Sounds simple, right? How should we decide big issues in a democracy? After all, if we can't use majority rule to decide big issues, why do we even vote? Douglas even had a name for his solution: popular sovereignty. The people are sovereign. The people in each territory will decide whether to admit slavery into it. Lincoln believed in majority rule. His defense of it in his first inaugural address against the threat of secession is second to none. Yet he returned to politics in 1854 to decry the new Kansas-Nebraska Act. Now, Lincoln had historical arguments against allowing the states to decide the slavery issue. Slavery in the territories had always been a federal issue since before the Constitution was even ratified. But Lincoln's chief target was Douglas's notion of popular sovereignty. The essence of Lincoln's argument was this: if one admits that slavery is wrong, he, quote, cannot logically say that anybody has a right to do wrong, close quote. Douglas couldn't, on the one hand, say slavery was wrong, and on the other hand, offer his fellow Americans the right to enact slavery in their territories. Even the American people in the ballot box, Lincoln said, don't have the right to do a wrong. John Locke, who hated slavery, would have agreed with Lincoln that any majority voting for slavery was as much of a tyrant as an individual. Locke believed that democracy was one of the forms of government that could be consistent with natural law, but a majority's vote was only legitimate if it was in accord with natural law. Thomas Jefferson said the same thing when he wrote of majority rule, quote, the people in mass are inherently independent of all but moral law, close quote. The people through majority vote are sovereign, Jefferson was saying, but moral law, that is, natural law, is even more sovereign. Hear out Jefferson again in his first inaugural address this time. Quote, all too will bear in mind that this sacred principle that though the will of the majority is in all cases to prevail, that will to be rightful must be reasonable, that the minority possess their equal rights, which equal law must protect, and to violate would be oppression, close quote. The majority's will, Jefferson says, must be reasonable, which means, as you recall, instructed by the law of nature and of nature's God. In a democracy functioning under Lockean liberalism, it's not just the will of the majority that prevails, but the reasonable will of the majority informed by natural law. Douglas, for his part, was saying in essence, Southerners think slavery is right, Northerners think it's wrong, settle it at the ballot box. Because Douglas believed in a majority unchecked by reason or natural law, the pedigree of his popular sovereignty is not the Lockean liberalism of the American Revolution, but the philosopher Jean-Jacques Rousseau's liberalism of the French Revolution. Now, to be fair to Rousseau, he never really intended for what's called his doctrine of the general will to be applied to an entire nation the way it was in the French Revolution. But at times during the French Revolution, whatever the majority decided was right, and the minority's opinion was often treasonous simply by virtue of its being the minority opinion. The minority's rights were only what the majority granted them. No moral law constrained the majority, or you might say the majority decided on what moral law was. That was the French Revolution model of liberalism. What we call liberalism today is akin to the liberalism of the French Revolution, which created new rights and put no restrictions on majority rule. Lockean liberalism, by contrast, is the liberalism of the American Revolution, which restored old rights, rights tied to our identity since eternity past as children of God, and restricted majority rule by natural law. Getting back to our antebellum drama, Douglas's popular sovereignty solution was so popular that it almost destroyed the Republican Party not long after the party's inception. When the territory of Kansas, under the new Kansas-Nebraska Act, set up two competing governments and constitutions, one slave and one free, Douglas argued long and hard in Congress in favor of the free constitution. Not because he thought slavery was wrong, but because he thought the pro-slavery constitution was not the true will of the people of Kansas. There were voting irregularities, border ruffians, Eastern Republicans, seeing the Democrat Douglas champion the anti-slavery cause in this indirect fashion, were ready to make Douglas a Republican Party leader. Seeing Douglas as their great hope, many Eastern Republicans resented Lincoln for challenging Douglas for his Senate seat in 1858. Lincoln's fellow Republican leaders didn't see any big distinction between the federal government outlawing slavery in the new territories and the territories' residents outlawing slavery there. What's the difference, they reasoned. Slavery is banned either way, and Douglas has found a way to do it that lets us objectify the slavery question. Putting it to a vote may keep us from a civil crisis. But Lincoln said, even the American people in the ballot box don't have the right to do a wrong. Lincoln, though, had an uphill struggle against the Republican groundswell in favor of Douglas. But something happened that complicated matters for Douglas just before his famous series of debates with Lincoln in 1858. In 1857, the Supreme Court decided the Dred Scott case. That case recognized a slaveholder's constitutional property right in slaves and reasoned that African Americans, even free ones, had, quote, no rights that the white man was bound to respect, close quote. While Douglas's Popular Sovereignty permitted the people in a territory to vote for slavery, Dred Scott went further, making slavery a constitutional right. In fact, as Lincoln pointed out, and as the South firmly believed, the Dred Scott holding cleared the way for a subsequent Supreme Court holding by the slavery-sympathizing court that all states were powerless to prohibit slavery within their own borders. Lincoln put it this way, quote, "We shall lie down pleasantly dreaming, thanks to Douglas's Popular Sovereignty, that the people of Missouri are on the verge of making their state free, and we shall awake to the reality instead that the Supreme Court has made Illinois a slave state." Lincoln's point was there really wasn't much difference at a fundamental level between popular sovereignty and the Dred Scott decision. Lincoln saw that slavery by popular vote was as much against natural law as the Supreme Court recognizing a constitutional right to slavery. It didn't matter whether it was the people who voted for slavery or the Supreme Court who found a constitutional right to slavery. Why didn't it matter? Neither had the right to do a wrong. In this unstable era in which new and evil philosophies were beginning to acquire the force of law, Lincoln alone asserted natural law. The transcript of the Lincoln-Douglas debates is fascinating because of how Lincoln argues natural law principles without even using the philosopher's terminology. Also because of the political theater. I've put out all the historical facts I need to here to make the points I'll make shortly. But I wanted to finish this antebellum narrative since we've gone so far together in it. Anticipating that the Supreme Court would back up his Kansas-Nebraska Act, Douglas had said for years that whatever the Supreme Court will say about slavery would be essentially infallible. When the Supreme Court finally did speak in the Dred Scott decision, it did in fact find the Missouri Compromise unconstitutional, paving the way for Douglas's Kansas-Nebraska Act. But Douglas did not anticipate what else the Supreme Court said, that a territory cannot exclude slavery. Douglas was caught in a contradiction. Which is it, Judge Douglas? If the Supreme Court is infallible and slaveholders have a constitutional right to slavery, then how can a territory vote against slavery in its borders? What happens to popular sovereignty? The resulting dilemma eventually caused the Democratic Party to split between North and South and caused Douglas, along with two other major candidates, to lose the 1860 presidential election to Lincoln. Many people have compared Roe v. Wade, the Supreme Court's 1973 case establishing a woman's right to an abortion, with the Dred Scott decision. Both created rights never contemplated by natural law. But maybe the similarity between the times and the issues goes further than just the common judicial activism. Pro-life advocates usually argue that Roe should be overturned and that the issue of abortion should be for each state to decide, just as it had been before the 1973 decision. Supreme Court Justice Antonin Scalia makes this point here. Quote, "It just seems to me incompatible with democratic theory that it's good and right for the state to do something that the majority of the people do not want done. Once you adopt democratic theory, it seems to me, you accept that proposition. If the people, for example, want abortion, the state should permit abortion. If the people don't want it, the state should be able to prohibit it." Close quote. Scalia wants abortion put to a vote at the state level, just as Douglas wanted slavery put to a vote at the territory level. Someone who understands abortion as the taking of human life might suggest that Scalia's position is better than the alternative, Roe v. Wade's decision creating a constitutional right to abortion. But let's look at the root of Scalia's and other conservatives' argument. The Dred Scott decision made slavery a constitutional right. Stephen Douglas said, "Let the people decide at the territory level whether to permit slavery." Lincoln, though, found them to be about the same. Dred Scott and Douglas's Popular Sovereignty have the same foundation. A ruler, be it a court or a popular majority, has no right to do wrong. Similarly, today, the Roe v. Wade decision made abortion a constitutional right. Justice Scalia and many other conservatives, including many conservative jurists, have said, let the people decide at the state level whether to permit abortion. Natural law would say a ruler, be it a court or a popular majority, has no right to do wrong. What I call modern liberalism, remember, has its philosophical roots in the French Revolution, which created new rights and put no restrictions on majority rule. It's not just today's liberals who are liberals under that definition. Many conservatives are too. Another Supreme Court quote, pop quiz, who said this? Quote, the whole theory of democracy is that the majority rules. That is the whole theory of it. You protect minorities only because the majority determines that there are certain minority positions that deserve protection. Think that one through. The majority decides on the rights of the minority. Any alarm bells going off? Okay, is this quote from A, Antonin Scalia, B, Ruth Bader Ginsburg, or C, Sonia Sotomayor? Once again, it is Scalia. I'm picking on the conservative position because this video series' intended audience is American Christians, particularly evangelicals. To point out the shortcomings of some of the liberals' views of majority rule would be preaching to the choir. But while many American Christians' views on many issues are more closely aligned to the court's conservatives, those conservatives' metaphysical foundation is overall as shaky as that of the court's liberal members. One side may favor abortion rights and the other side oppose it, but generally both sides believe that either the court, in the liberals' view, or a state's people or legislature, in the conservatives' view, may permit a woman to end her fetus's life if she so chooses. In other words, the conservative side believes that the majority decides what is morality. But what alternative do we have? As one jurist has said, quote, there is no way to decide these questions, placing moral positions at odds with one another, other than by reference to some system of moral or ethical principles about which people can and do disagree. Because we disagree, we put such issues to a vote, and where the Constitution does not speak, the majority morality prevails, close quote. This advocate for majority morality was Judge Robert Bork, the conservative jurist whose nomination to the Supreme Court was scuttled during the Reagan administration. This majority morality he advocates is one of the main premises of his famous book, The Tempting of America. Its philosophical foundation is a form of liberalism straight out of the French Revolution. And the answer to the implicit question in the judge's statement, who decides when people are split as to what is moral, has already been answered by Lincoln. Not the majority, Judge Bork, but the natural law that provides the historical and philosophical platform for our nation's founding. My point isn't to offer a solution to the abortion issue, but to illustrate how Lockean liberalism differs from what we call liberalism today. Lockean liberalism generally doesn't offer solutions or governmental structures. It offers a metaphysical structure that we learned about in our last episode, and it insists that no matter how a government is framed, it must be consistent with natural law and rights. Lockean liberalism also tends to put conscience before solutions. It tends to say no to unprincipled ideas and to let people open to reason, that is, to nature and to nature's God, to lead them to resist others who value results over reason. As I mentioned earlier, Lincoln believed in majority rule and defended it forcefully in his first inaugural as the southern states were seceding from the Union. Lincoln's election turned out to be the last straw for the South and the immediate cause of the Civil War. More on that in our next segment, which deals with one root in modern conservatism. Today's liberalism, then, in some way harkens back to the French Revolution, which created new rights and put no restrictions on majority rule. Lockean liberalism, by contrast, is the liberalism of the American Revolution, which restored old rights, rights tied to our identity since eternity past as children of God, and restricted majority rule by natural law.